Next is number 17, Ryan Makepeace, cause number 5Z204895.
Give me just a moment, please. This is a continuation of a defendant's motion to dismiss or suppress and dismiss as a result of a violation of the infraction rules regarding discovery. And what I tasked the city to do was to tell me whether there is a distinction. Well, let me just read the rule back onto the record. I know I've already read this once, but since Mr. Rice wasn't here before. Under the infraction rules 3.1b, it states upon written demand of the defendant at least 14 days before a contested hearing filed with the court and served on the office of the prosecuting authority assigned to the court in which the infraction is filed, and I did find that part of the rule was complied with. It goes on to say the prosecuting authority shall at least 7 days before the hearing provide the defendant or the defendant's lawyer with 1, a copy of the signing officer's sworn statement, 2, a copy of video or photographic evidence, etc., etc. The argument that was made by Mr. Brown, as I recall, was that the city made the discovery available to the defendant and that the defendant failed to follow through with picking up that discovery or providing an email address where the defendant, where the discovery could be sent to the defendant. My question to Mr. Brown and now is to Mr. Rice is if there is a distinction between providing discovery and making discovery available. And that was basically the sole issue that was to be researched and brought back and discussed. So I guess I will, since Mr. Brown isn't here, put the question to you as well. Mr. Rice, is there a distinction between the two?
Well, Your Honor, our position is that in this case we don't need to reach that question because the defendant in this case, Mr. Mendes, did indicate his desired method of receiving discovery, which is that he would pick it up. And that's in the exhibit we filed with our motion to discuss response.
Right, and that's this form here.
Right.
All right, I'm going to ask the clerk to mark that as an exhibit.
So our position in this case is because Mr. Mendes indicated his desired way of picking it up, and we complied with that our obligation to the agreement was met. Otherwise, we are left guessing or having to provide discovery via means contrary to what they've indicated to us. So when they clearly indicated that they will pick up discovery and leave a phone number and comply with that, it's our position that under 3.1b, that's exactly what we're required to do.
All right, I'm going to receive one into evidence. So, and I looked at Exhibit 1 when it was provided and considered it and also considered the rule. And looking at the form that the city apparently sends to defendants regarding discovery, a defendant is said to choose one of the following. It says mail discovery to above address, and then and it requires that the defendant include a self-addressed stamped envelope. 2, email discovery. Or 3, I will pick up discovery. Please call, and then it gives a phone number when ready. So my question to you is, does that not require any defendant who requests discovery to act proactively, irrespective of whether or not what their election is? Does it require a defendant to act proactively? That's the first question, and that can be answered with a yes or no.
Yes.
All right, so it does require a defendant to act proactively. And so my next question is, does the rule require a defendant to act any more proactively than what the rule prescribes? Because the rule does require the defendant to act proactively. It does say that you must make a written request. But other than that, does the rule require the defendant to do anything else?
There's nothing I've seen in 3.1 that would require any additional action from the defendant.
So applying the rules of statutory construction, my question to you is whether or not the language at the bottom of the form that the city uses, choose one of the following, go beyond what the rule requires. Including requiring the defendant to have to pay. Because providing a self-addressed stamped envelope actually requires the defendant not only to act proactively, but to spend money.
Correct.
And the infraction rules say that there shouldn't be any costs associated with these hearings, borne by the person who was said to have violated the rule of the road. Because I believe that applying the rules of statutory construction, if that's what the promulgator of the rule contemplated, then applying the rules of statutory construction, they would have put it in the rule. Self-addressed stamped envelopes and that sort of thing. There are other places within the court rules where those type of requirements are in there. But in the infraction rules, it specifically states these rules govern how infractions will be handled by the courts.
I guess the flip side of that, though, is that if it was intended that my response is that the city's method of providing discovery complies with the rule, because the rule requires that we provide the defendant with discovery. And so under...
But doesn't that go back to the initial question? Whether the term provide is analogous to make available. Because that's actually what you're doing, is it not? You're making it available. By the defendant selecting one of these three options, you're making it available. And then once they select one of those three options, then you provide.
The alternative, right, is that we have no way of knowing how the defendant would elect to receive discovery, so we have these various methods which we're left to guess at.
You don't have to guess. I mean, it seems to me, and I don't know how other jurisdictions handle this, but it seems to me that when you're served with a request, you just mail it to them.
But I guess that if that was what was intended, then that would be in the statute. But it's not in the rules. But it's not. It's left open-ended in that case. It doesn't require that the discovery be mailed. It's that it's provided. The city's interpretation of provided is to provide this form so that the defendant can choose how they want to proceed discovery.
Well,
So again,
I got to say that I don't make this particular decision in a vacuum, because we do have a way that we can consult with our clients to see if our clients have dealt with this situation. And so I sent it out to colleagues. Sent it out to my colleagues. And of the colleagues that responded, I believe it was like 13 to 15, each and every one of them interprets the rule the way that I do. And it's how I interpreted the rule initially. But I didn't want to just guess before I went out, because there's no case law on this.
right.
Before I went out and asked other judges, how do you look at this? How do you read the statute? And then how do you view the options that are provided by the city when there's discovery requests made? And without exception, they all said it requires a defendant to do something that the rule itself does not require a defendant to do. I understand your office's position, but I'm going to grant the defendant's motion to dismiss, or to suppress and then dismiss. And I would encourage your office to re-examine this process. This is the first time it's come up in 17 years that I've been here. Okay? It's the first time it's come up. But it's also the first time we had an opportunity to actually see the form that's sent to the defendant. So I'm going to grant your motion to dismiss for the reasons I've already stated. And, I mean, I can't require the city of Renton to change what they do in terms of how they conduct their business, they being the executive. But I do believe that in this particular case, that not only was the spirit of the rule violated, but the letter of the rule. And so your motion dismisses, granted.
Thank you, sir. Thank you for contacting your colleagues and going the extra mile. I appreciate that.
You're welcome.
All right. We do have a case.
See y'all later.
Goodbye.
I need to sign anything? Or?
Nope.
Nope.
Okay, thank you all.
You're welcome. What do we know about Mr. Fidgetman? There's nothing in the document.
You know,